When a debt collector calls 15 times a day or someone trashes your business online, it feels overwhelming. Your personal life gets hijacked. You find yourself stuck in a trap. Doing nothing guarantees the abuse continues, but picking up the phone to hire a lawyer at $300 an hour might feel financially impossible just to get started. There is a middle ground. It's the do-it-yourself cease and desist letter, and it serves as a formal, professional starting point for your response. Let's clear something up right away. A cease and desist letter is not a legally binding court order. It is not a magic shield that physically stops someone from typing a bad review or making a phone call. The real power of this letter is that it creates a formal, documented paper trail. It proves you gave clear, legal warning before escalating the fight. When facing unwanted behavior, you have three options. First, ignore it, inviting more abuse. Second, send an angry text. Neither protects you legally. The third path is a formal cease and desist. This puts them on notice and starts a timeline of hard evidence. But a successful DIY letter cannot just be a generic rant. It requires specific legal phrasing targeted directly at the type of threat you are facing. Drawing a successful legal boundary relies entirely on matching the right document to your specific problem. To show you how this works, we are going to break down three specific playbooks. Our first scenario is the overwhelmed consumer. You are getting hammered by daily, harassing phone calls from third-party debt collectors. To stop them, you need to cite the Fair Debt Collection Practices Act. The specific legal mechanism required for this letter is Section 805C. The mechanics here are straightforward. Federal law dictates that once a collector receives this notification in writing, they must immediately stop calling you at home, at work, or on your cell phone. If they violate this written demand, they face regulatory action. You can file a federal complaint with the FTC or your state attorney general. There is a crucial trade-off you have to accept here. This letter absolutely stops the harassment, but it does not forgive or erase the underlying money you owe. After receiving the letter, the collection agency is only legally permitted to contact you to say they are ending collection efforts or taking a terminal action, like filing a lawsuit. This specific template is highly effective because it takes an emotional plea to stop calling and transforms it into a strict federal compliance issue they cannot ignore. Our second scenario involves a small business owner or freelancer watching their reputation get actively destroyed by false online reviews or statements. The boundary for defamation is strict. This letter only works if the statements being made are objectively and demonstrably false. It will not protect you against negative opinions or mean-spirited truths. As this matrix shows, a defamation scenario requires a very specific input. You must explicitly list the exact false statements in the letter and demand an immediate retraction. In many jurisdictions, sending this formal notice of defamation is a legally required prerequisite before you are allowed to file a lawsuit in court. The major risk here is your target. Firing off this letter to a dedicated, anonymous internet troll might just agitate them and cause them to double down on the abuse. That is why this specific letter is best deployed against a rational actor, like a competitor, an ex-client, or an established business. These are people with financial assets who are afraid to lose them in a lawsuit. A defamation cease and desist acts as a strategic filter. It tests whether the person defaming you will fold under formal pressure before you actually have to spend money retaining a lawyer. The final scenario deals with internal betrayals, a business partner or ex-employee leaking proprietary trade secrets in violation of a non-disclosure agreement. To execute this template properly, you must attach the originally signed NDA as Exhibit A and direct proof of their leak as Exhibit B right inside the demand. The specific demand in this letter requires the recipient to provide written confirmation of their compliance within exactly 24 hours of receipt. That tight deadline instantly shifts the psychology of the dispute. It moves the situation from a casual disagreement into a formal breach of contract event. But here is the critical trade-off. By drawing a hard line with a 24-hour deadline, you are making a threat that you absolutely must be willing to back up. If the violator calls your bluff and ignores the letter, you have to be prepared to escalate to actual litigation. If you do nothing, you lose all future leverage. An NDA cease and desist serves as a final warning. It forces the rogue party to immediately calculate their own financial risk of being sued. DIY templates save thousands of dollars and can descend in minutes, but their success relies entirely on the recipient respecting formal consequences. Look at this quadrant chart comparing budget against threat severity. Low threat, low budget. Block them. Severe threat, high budget. Retain an attorney. But if the threat is severe and your budget is limited, you land right here. A DIY template is your first step. A crucial safety disclaimer: if you are dealing with a physically dangerous stalker, skip the letter entirely and go straight to the police. Physical safety always overrides a paper trail. For those of you sitting in that DIY quadrant, the solution is the Cease and Desist Letter bundle from Noble Notary and Legal Docs. For just $9.95, you get instant access to editable Microsoft Word documents for all 3 scenarios we covered today, plus an additional template for general personal harassment. You don't need a law degree to stand up for yourself. You just need the right paper trail to prove you mean business. Check the link in the description to download your bundle today.